Good morning, everyone, and welcome. My name is John Rogers. I'm Environmental Manager with the Utah Division of Oil, Gas, and Mining, and I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this matter. Today is Wednesday, September 20th, 2023, and this is the time and place for the hearing examiner proceedings for docket number 2023-040, cause number 132-22. In the matter of the request for agency action of XCL Resources, LLC, on behalf of XCL Asset Company, LLC, for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1280-acre or substantially equivalent drilling unit established for the production of oil and gas and associated hydrocarbons from the Lower Green River, Wasatch Colton formations, comprised of Section 21 and 22, Township 2 South, Range 3 West, Utah Special Meridian, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resource Building in Salt Lake City. This is a new procedure for this presentation before hearing examiner. I have received declarations from witnesses and reviewed them before this hearing. The proceedings will broadcast, correct myself there, it will not be broadcast, it will be recorded for view later if it wishes to be. So I wish to thank the division legal staff, the division staff, petitioners, and department technical staff for allowing this process to go forward both remotely and in person. We will take appearances of counsel at this time.
My intro music. Mitch Mayo of Lear & Lear PLC on behalf of petitioners in this cause, XCL Resources and XCL Asset Co.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
And my counsel, Elizabeth Harris at the Attorney General's office. We'll proceed to Mr. Mayo at this time.
Thank you, Mr. Rogers, counsel and staff. Appreciate this proceeding today, and I know it's novel. Hopefully it's a good exercise and works out well. If there's any feedback on the procedure or the way it goes, please let us know so that we can improve. For the matter on hand, at the risk of repeating too much, I will try and keep a brief introduction. As I said, Mitch Mayo of Lear & Lear PLC on behalf of XCL Asset Co. and XCL Resources LLC. With me today by remote participation are Mr. Kevin Annenson, Vice President of Business Development and Land, identified with a raised hand, and Mr. Mark Gravy, the Executive Vice President of Reservoir for XCL. It's probably appropriate to have both the witnesses sworn in at this time.
Yes.
Please raise your right hand. Right hand, please. Do you solemnly swear that the testimony shall give in this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Division, do you have any objections? No. Okay. Have you?
Sorry.
Did you review their expertise, or do you want to go over that, or have a desire?
Look through it.
Both of these witnesses have been recognized as experts in their respective fields by the board in prior causes. Most recently, and I don't have the cause number on hand, but it was in May or April of this year in a compulsory pooling matter for the same parties. Presumed stipulation. I'd like to have them as experts in their fields in this cause as well, or their declaration testimony considered as expert declaration testimony in this cause.
I'm sorry, could you raise your voice just a little?
Yes, I'm sorry, I will do that.
It's harder.
I appreciate it. Just have a microphone right next to you.
Yeah.
Okay, we will, with no objections, we'll accept them and their expertise in their study. I've reviewed these affidavits beforehand, and well, would you like to say any more, Mitch, before I can, have questions?
Really, the introduction is to serve the group here. So if everyone feels comfortable that they understand what's happening in both of these and what the requests are, I think it's totally appropriate to move into questions.
Okay. I've reviewed both affidavits and feel very comfortable with them. But I do have some questions I want clarified. And as we go through these force pulling matters, each one seems to be a little bit different. And so I want to just get some understanding. So I'd like to refer to the request for agency action. Now, let's first look at page 2 of that. There is a list of individuals on there It says this request includes the compulsory pooling of the following owners, and they list them. And then at the bottom, it says who are either unlocatable or have refused or failed to agree to lease or otherwise bear their proportionate share of costs of drilling and operating, plugging and abandonment of the following wells. So they list the wells later. That there's 5 wells there. This list, then we go to another list, and then they call this other list on page 3, 21-22 unknowns. Now, what is the difference between that list and the second list?
Well, from a legal perspective, we have to give names to a lot of these pieces of information because these pleadings are dense to begin with, and there's a lot of information. So we try and call out capitalized terms, unknowns in this instance, to signify. The distinction between those two terms in this is in that first list on page 2, it says these parties are either unlocatable or have refused or failed to agree. Now, the truth is they are known. We know who these people are, so they're not unknown. They are unlocatable and or just have refused to agree. So that's where that comes in. The second list on page 3 of the request that identifies the estates, we're pooling the estates. And one of the problems is we don't know definitively under Utah law who their heirs are. So technically every potential heir is unknown under those parties. So we choose that title simply to be descriptive, not to in any way say there's no one else unknown in this unit, if that makes sense.
Okay, so these are the original estate owners.
So there's two groups of people that typically get pooled in these. One are parties who have received an election. We know who they are, we know what their address is, they've received their mail and refused to participate or haven't responded in time.
And that's the first list.
The first list includes that, and it includes people who we just don't have addresses for. That's the first list. The second list is these parties own record title, but for some reason in the record, there isn't a probate, there isn't evidence of succession. What we have often in Utah title is parties will get contacted. Let's pick the first name on the list, A. Austin Smith. I like to imagine he was a rancher out there in the 60s and died. And oil and gas wasn't that hot in the 60s in the basin, so no one paid attention. 20 years later, someone came out to get a lease, found A. Austin Smith in there, and found another Smith in the basin who said, yeah, I'm his grandson. They executed a lease, and because the probate period had ended and the parties didn't know the information, the company at that time assumed the business risk that they knew who Austin Smith was, and it was done. What happens is in 2023, you go forward and if you track these interests from patent all the way to present, there are countless situations just like this where people died, a probate either wasn't done or it wasn't recorded against the lands. So there is no evidence of succession. But what parties do often is they'll file of record an affidavit of heirship. Wife, A. Austin Smith's wife, will file an affidavit that says, I am his wife. I was alive when he died. We have 2 kids of our marriage, and he had 1 kid before his marriage. So it all goes to whatever the answer is. Oil companies have a choice at that point in time. They can suspend A. Austin Smith's interest in perpetuity, knowing that no one will probate it. Or they can assume the business risk that A. Austin Smith's wife, who they are convinced is A. Austin Smith's wife, is telling the truth about succession. That's a business risk, but it's oftentimes better than leaving these folks with no remedy, given that time has passed. The problem is in Utah law, an affidavit of heirship isn't conclusive proof. It doesn't pass title. So oil companies are stuck in a conundrum. Of record, A. Austin Smith still owns an interest, but he's been dead for, and I don't know anything about him in particular. He's been dead for 50, 60 years. It really should be held in whoever his heirs or successors are. If he died and had 2 kids and no wife, it goes to his 2 kids, absent a will. And if his kids had died, you track it down to his grandkids. If we knew that of record, then we would send election letters to each of those grandchildren individually, those that had addresses. Because we don't know that, if there's an affidavit of heirship of record, or if there's some non-record, non-marketable title evidence that exists, it may get called down in one of the heirs, even if it's not formally there. So that's a long and complicated way of saying Utah title is messy. and there is often a lot of interests that are just kind of stuck in time. That's why you've seen over the last couple of years a number of operators come in and start pooling a significant number of estates out of an abundance of caution, because probates do happen. You know, they'll have one done in Colorado 20 years ago. And when the parties realize this and finally, you know, are contacted in some way, they record that probate against the Utah lands, and the oil operator is in a pickle. And so operators have started saying, we're going to go in and pool proactively out of an abundance of caution all of these states that we can find as owners where the record mineral interest is technically held in those estates still, just to make sure that everyone who does or may own an interest in this is legally pooled as previous unit.
So A. Austin Smith, for example, is it the oil company's position that they've done their due diligence by recognizing him and not doing the genealogy by just recognizing him? Or do you feel that the oil company does the genealogy as well as they can? I mean, what's the position there? Or they take that choice?
Both. I mean, under Utah law, for better or worse, they're only required to notify record owners at their last known address of record. So anything beyond that is for the companies and the broader community's benefit. And most companies see benefit to themselves and to their mineral owners and going beyond that record. The truth of the matter is there's only so far whitepages.com, ancestry.com, Google can get you in finding someone with the last name Smith. And so doing the genealogy for A. Austin Smith is in some ways a fool's errand. What you look for is, so yes, they do look for it, but honestly, it's.
Can I jump in, Mitch?
Oh, please, I love that.
Hey, John, how are you? I'm gonna turn my volume. So just to add. Let me turn this down. Yeah, we get those titles. Like Mitch was saying, it's always a benefit for us. We always, you know, do the diligence to go find any one of these folks. Just like Mitch was saying, we actually because those are obviously costly as well. So doing the work to do this ahead of time, you know, works for us. And then also we have a set of brokers, you know, I say brokers, another set of landmen that work for XCL that also are trying to, you know, find these folks, lease them, call relatives, things like that. In these instances, there's nothing filed, you know, in these counties, most instances anywhere, or, you know, have any type of will. So, you know, these folks are out there, you know, working their tail off to try to find them so that we can have them in XCL's working interest. And in the instance that we can't, you know, as you guys know, there's not a ton of wills and probates done in the more rural areas, so it makes it a little bit tougher. But you know, we absolutely do everything we can to go find these folks. And you know, before us, even, you know, before we even got the asset, Axia did the same thing, and you know, they were a very competent group as well. So to say we dot every I and cross every T, I think I can confidently say that we do in order to find these folks.
So the remedy for A. Austin Smith, just because he's the first on the list, is that you will collect his royalties, put them in suspension, and in process turn them over to unclaimed property in time.
We'll just cheat them with the state in the instances that able to ever find any type of trail. We'll just cheat it. We'll just cheat that at that point. You know, if Corey Austin Smith, we'll keep using his name, if he or his family or grandkids or great grandkids, whoever is ever come out and they are able to show, you know, proper passing of title, then we'll release those funds to the proper record title owner.
Okay, I just wanted to see how that process works.
Yeah, no, great question.
Back to the first page. So on there, we have 1, 2, 3, 4, 5. These are what you call the locatables. Well, they're unlocatable, but you know who they are, so to speak. Player, Oil and Gas, Gill Holdings, Ronald J. Cook, Spencer Merrill, and Barbara A. Butler. Why are they not included on the second page of unlocatables?
Well, so go back to, you said page 1, and there's 5 people. I'm not.
Yeah, you mentioned later on in your request, those 5 individuals were unlocatable.
Okay, so that's a good question. The first list on page 2 includes all the parties that we know who are either unlocatable or who have received it. We know where they are, and they've received it, and they just didn't respond timely, or they just ignored it. So it includes 2 groups. But because the ex parte motion is aimed at just one of those groups, this list is designed so that everyone in this room, everyone who receives a copy of this says, these are the parties that are being pulled. The second list, this later on that identifies 5 people, identifies anyone that we believe doesn't have a valid address of record and is being pooled, so they need to be covered by that ex parte motion for publication.
So you know where Player Oil and Gas is. You sent them a
We
letter.
have an address of record for
On
Player
the other
Oil and Gas.
individuals, you have no location whatsoever on the second pages 3 and 4.
Well, on a lot of folks, and this is not specific to this request, but on forced poolings in general, a lot of the people that we notify as unlocatable, we have a pretty high level of confidence that that is their address. But over a 3-year period of time, sending them 20 letters, they all come back returned undeliverable, or they just wait for 2 months and then they send them back because they didn't pick them up, which is a common thing.
But so the second page though could be, you know who they are, where they're at, but you just don't know they're the rightful owner.
Well, and a lot of this, you have to, that's exactly right. And a lot of this you have to remember, we're trying to go above and beyond to make sure that this order, once secured, is protected from subsequent attack. And so there's a lot of, and you hear this a lot in these hearings, abundance of caution, right? We notify, let's go down to that list. I'll look at it on mine so I can talk in real terms here. Let me see. Yeah.
Page 8 is where you're at.
So Player Oil and Gas Company has an address of record on the certificate of mailing. We mailed it to them. But because we've had no ability to communicate, they haven't responded or acknowledged anything, the company's stuck. We feel fairly confident that this is their address of record. It is their last address record. We believe it's still valid. So technically, we don't need to notify them by publication, but we can't be certain because no one's ever responded. So out of an abundance of caution, we'll also include them with published notice so that no one can come back and say they didn't get notice. If
Okay.
that makes sense.
That's why they're listed twice. More than that.
That's right. The first list is so everyone who gets this request can turn quickly and say, okay, I'm not on there. The second list is just to explain that we're also going to need an ex parte motion for service by publication because some of these folks don't have addresses or they're just not responding and we can't be certain that's their address.
Any more questions from the division?
Nope, none at this time.
Okay. Well, I appreciate that clarification. And sorry,
No.
I'll have to go over it again next time we do this, but it just gets very, everyone uses some different terms and it gets convoluted. I just want to understand
Well,
what these names mean.
hopefully there's a trend towards kind of combining all the styles. You know, there is a bunch of different ways to go about it, but I know I've made a concerted effort. I know other councils I've talked to have made a concerted effort to try and standardize to the extent we can these pleadings so they feel familiar and everyone can see exactly where the information is. But if there's a suggestion on how to present it from anyone to improve it, I'm happy to consider.
Actually, can I just ask something? So for instance, maybe this will clarify something. Oh, so Spencer Merrill is listed.
Yep.
And then on the summary of these earners, it indicates that he is no address of record, unlocatable. So am I to assume that he was someone that was just a record title and in the vesting document, he had no address? And that's all we have.
And that happens, and that happens fairly often,
Yeah.
unfortunately. Or it could be a situation where he is mentioned on an affidavit of heirship, for example. Company has supreme confidence that it is the heirs. It's not fully solid, but they have no doubt that he is one of the heirs, but it just says Spencer Mano without an address. So that's exactly right.
I guess I do have a question for this one. I think it's actually for the next matter, but I just want to make sure it's not applicable to this, because I did get a call from an individual wondering, you got notices from XCL on the matters that were happening today. And
Was it a mistake?
he was a grandson. So his name was
Eldridge?
James Hanson.
Oh, Paul
And I
Soren.
think it's Paul Hanson's grandson. I think he mentioned Paul, and I didn't write that down, so I apologize if that's correct. I just wanted to make sure in this case, we don't have an issue, and need to discuss this, and maybe we have to on the next one. He indicated that he had reached out to XCL, and had talked to them, and they were going to get back to him with some information. I did talk to him for quite a while as far as asking some questions, basically saying you need to probably talk to XCL, see where your status is. He indicated he was getting royalties on other wells in the area. It sounded like he had a lease. What he told me, his original contact with XCL was that he wasn't being affected by this matter. So that kind of indicated he probably had a lease, but I don't know. He did say he was going to get some follow-up that following day. So he called me on September 11th. I called him back on September 12th. So we had this discussion on September 12th, and XCL was supposed to get back to him later that day. I never heard from him again on this matter. So I just want to make sure.
It is in the next matter. I'm happy to answer it now. If you want to just say it's set up, we can kind of hop right into that.
Why don't we handle the next matters?
I just want to make sure, because he didn't indicate which matter it was.
But it
I
was
do
taken
see
care of.
it was taken care of.
It's
So,
in the declaration.
but it's-
Also, it's where it is.
yeah, and I saw that you had mentioned stuff about Paul Henson, Paul Henson. But I just want to make sure it wasn't on this one, make sure that was clear.
Yeah. Thank you.
Okay, if you're all right, we'll bring that up in a few minutes when we start it. Okay, any more input from the division?
No more?
Okay, well, I have reviewed the affidavits and you're asking for a 300% penalty. That's within the reason what we've done historically and short pullings in this area. So I think that's fine. We have a average. I looked at the royalty, and the average rated royalty calculated out to 16.515736. Feel comfortable with that. And 98.295534% have agreed to participate or lease. So that's pretty significant. So at this time, I would turn the time over to you, Mitch, to summarize if you want, or if you have anything for your witnesses that they'd like to add.
Yeah, Kevin, Mark, anything you'd like to add based on what you've heard and what Mr. Rogers just said?
I do not.
I think we're good on that. I guess we submit, accept.
Okay?
Was that a ruling?
No, not yet. I want to discuss something with my job.
Take a brief
Back
break.
in a few minutes.
While they do that, I'm gonna call in my other phone because I have an echo.
I think the echo is they have to mute.
Oh, is it echoing for you too?
Yeah, so go ahead.
Oh, so when we talk,
So I was just gonna make sure.
And it's good.
Try it now and we'll mute you. Mute it already.
give me the thumbs up when it's muted. Oh, there we go. Now I don't hear an echo.
There's another one.
Okay, are we back on the record or still going? Okay, this time I would ask that we have the affidavits and the exhibits submitted for the record.
You know, actually, it's probably not a bad idea since they're declarations and they're unsworn and the witnesses are here, maybe have them verify that this is their sworn testimony. Unsworn declarations are admissible in Utah courts just as affidavits, but I always prefer the person saying it themselves. So maybe just quick question. Kevin, you've reviewed your declaration on file on this cause?
I have.
And is it your full and accurate and sworn testimony in this matter?
Yes, it is.
Mr. Gravy, same questions. Is you familiar with the declaration on file?
Yes, I am.
And is it your full and accurate and testimony here for this matter?
Yes, it is.
Okay, thank you. Just to
Okay, well, that's a good
Well,
point.
sure.
Since we're new to this, it's probably good to have that.
And let's just make sure they're all admitted into evidence,
So
they're admitted.
you're admitted.
exhibits, I'll move for, or I'll request admission of exhibits A through J in this cause.
Accepted. And
I believe that's in the other one, isn't it?
okay.
No, here's the exhibits.
Oh, thank you. Actually, got them pulled up too. What am I thinking? I should show here. Oh, yes. A through K. Thank you.
Okay.
Wait, sorry. There's an L as well. Supplement exhibit L.
There is a supplement exhibit K in this matter.
Oh,
There's a
that's what's
supplement exhibit L. Essentially, we send the certified mailings. Some of them come back within a week, some of them come back the day before the hearing. So we try and supplement the exhibits. There's a supplemental exhibit K in this one that includes, I think, Barbara Butler, maybe.
Is a supplemental exhibit L.
Not in this matter, because we don't have an exhibit L in this matter.
Oh, that's right.
So there's supplemental exhibit K. There should have been a supplemental exhibit K in this matter. That's an updated proof of service with additional that we received. And in the next matter, I believe there's a supplemental exhibit L. It's the same.
Right.
If we receive any more, we'll obviously file a second supplemental prior to the board hearing, just to complete the record.
Okay, in my opinion, that as we.
I'm sorry.
No problem.
There is this.
Yeah, we do have it now.
I do have a supplemental exhibit L. I thought I did.
Is it possible that maybe we just put the wrong docket and cause number on it?
It is.
I think we just misidentified it. Okay, we'll clarify. This exhibit, though, is the supplement to the proofs of service. So it's just an updated return of service for this.
So you'll get that straightened out before.
Oh, Julianne, that's for the next one.
It says right on here, docket 2023-043, cause 133-22.
Oh, yes.
Well, that's on the header, but it is filed under the other one.
Yeah. I think we just messed up the header and filed it appropriately, and you filed it appropriately in the right cause. It's just we put the wrong information.
So this should go in the other file.
It's already filed in the other file. It just has, at least that's
That's where I pulled.
that's where I understood it. Yeah.
Okay, that's not where I have.
Okay, so we've got A through K
A
in
through
this
K
manner.
and
Okay.
K was supplemented.
And
And
K
we'll
was supplemented.
clarify that to make sure that's right.
We'll make sure the file is reflective of that.
This is. Yeah. Oh, wait.
Everyone,
132.
Yeah, that's what I thought.
This one. This one has K. Oh, the K is a 132. Yeah,
But we
so 23 has K.
so we just flipped the headers on them when we filed
You've got 130-22 with L file, and you've only got K filed in 133.
Right. That's not for the header signs. So
Yep.
they are in the wrong.
So we just need to flip them and we'll correct that. I'll send you that this afternoon so that we can make sure the record's clear. So I guess it's appropriate to ask for admission of exhibits A through K and soon to be filed supplemental exhibit K.
Well, I did just check. Supplemental Exhibit L for cause 132-22 is for Barbara Butler.
Okay.
I checked the request for agency action and Barbara Butler is listed for cause 132-22 in
She's
on
on,
page 2.
she's on both,
She's on
and I think both
Yeah.
supplemental exhibits are her, so it was just a heading mistake
Okay,
that got.
okay.
Thank you.
I think I have it.
I'll clarify it with you after just to make sure.
Let's start over again now.
I think so. Supplemental. I'd like to request admission of exhibits A through K and supplemental, soon to be finalized supplemental exhibit K.
Accepted as stated. Okay. All right, it is my opinion as a hearing officer that we accept the request for agency action I've submitted and present this to the board. Mr. Mayo, would you prepare that order for review for the division and myself?
I will, and I'm going to try and work on those as quickly as I can. I've got a lot of prep for next week's hearings, obviously, but I'm going to try and get those to division and hearing examiner council by the end of the week, if possible.
Okay, we'll close this matter and continue on with the next. Thank you.
I guess to me, the note that no one showed up. Doesn't matter.
These are very important things.
Lots of people showed up. No one to.
No member of the public.
Thank you. I appreciate it.
Yes, we have no member of the public, only staff from the division and your witnesses. So, okay, thank you. Okay. This is going to sound very familiar. We'll start here. Good morning, everyone, and welcome. My name is John Rogers. I am environmental manager with the Utah Division of Oil, Gas, and Mining. I've been appointed by the board in Oil, Gas, and Mining as a hearing examiner in this matter. Today is Wednesday, September 20th, 2023, and this is a time and place for the hearing examiner proceeding for docket number 2023-041, cause number 13223. In the matter of the request for agency action of XCL Resources LLC on behalf of XCL Co. LLC for order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within the 2,560 acre or substantially equivalent drilling unit established for production of oil, gas, and associated hydrocarbon from the lower Green River, Wasatch, Colton formations, comprised of section 15, 16, 21, and 22, Township 2 South, Range 3 West, the Special Meridian, Duchesne County, Utah. We are holding this hearing the anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. This is a new procedure for the presentation for the hearing examiner. I received declarations from witnesses and I've reviewed them before this hearing. I wish to thank the division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forth remotely and in person. We'll take appearance of counsels at this time.
Thank you for that. Mitch Mayo of Lear & Lear PLC on behalf of the petitioner in this cause, XCL Resources and XCL Asset Company.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
My counsel is Elizabeth Harris of the Attorney General's Office. I'd like to proceed to Mr. Mayo at this time.
Thank you for that. We appreciate you guys holding this hearing today. We understand it's a new procedure. We're looking forward to trying to finalize a best practices approach. So any feedback is greatly appreciated. As in the earlier matter, this is a fairly straightforward compulsory pooling. Notice was provided to all owners of record entitled to notice. And as of yet, we've received no response or elections other than as mentioned in the declaration. I think it's probably appropriate, unless you'd like me to go through those, to turn it over to some questions, and then we can kind of hit on those.
Okay. The questions I had are very similar to the first matter, and I feel comfortable with the answers that were provided by you, Mr. Mail. If the division has any other questions concerning that, but I have no questions at this time. I know the division had something they wanted to bring up.
Yeah, as mentioned previously, the first question was a phone call we received from James Hansen. I know it's addressed in the affidavit. If we could have just a little bit more explanation on how that will be resolved.
Yeah, Mr. Anderson, can you hear that question? And are you in a position to kind of give him a little color on the estate of Paul Soren Hansen and his, I guess, grandson or son who reached out and mentioned that they're leased and kind of why they're being removed from this request?
Yeah, they were the ones that they hadn't, I don't believe they had probated yet. And so once they properly probated, we had removed them because we actually have the chain of title. But yeah, they've been removed from the record or from the hearing.
So essentially you hadn't seen proof of their probate of his estate. They provided it, and now you know that the heirs are conclusively determined and all committed to the will.
That's correct.
Let me ask a question there. So once it's not probated, but you know what really is going on there, but you really don't want to do anything until it's officially and legally probated to go forward, is it the position of the company to be conservative until the probate is complete? When you talk about being removed, does that make any sense?
I mean, each operator is different. So I guess the business risk in assuming, maybe the business risk in assuming to kind of follow an affidavit of heirship versus the business risk in waiting for a full and final probate. Can you kind of talk through that, Kevin?
Yeah, I mean, it depends on, a couple factors. It's not always just one, but, depends on the size of the interest, because a lot of those are business risk that we choose to take on. And what I tell our folks a lot of times are, when you drill one well, and let's just use an instance, where someone has 1% and we accidentally pay the wrong person because we went by an affidavit of heirship. Now you go drill 10 wells. Now the mistake is 10 times as bad if we decided to go off of an affidavit of heirship instead of going off of an actual probate, which properly passes title. So it depends on those scenarios as far as like exposure that it has to XCL. Now, if, let's go to A. Austin Smith or whatever his name was, our buddy from the previous ones. Let's assume, he gets properly probated and we were going off an affidavit of heirship and paying the wrong person. Well, that's on XCL. We got to go back and, what we call PPA, which is post prior adjustments. And we got to go pay Austin Smith and, the other person that we paid, they kind of reap the benefits of it. So it's really, I think in a nutshell, it really just comes down to the business risks that XCL is willing to take on. And like I said, as we continue to do full field development, as you guys know that we're doing, where we're putting, anywhere from 7 to what's the most we've done, 13 wells in a particular DSU. It just, what is that exposure to us? And so obviously as that exposure and those numbers get higher, we get more cautious and we decide, hey man, we actually need a probate. It's worth the $1,500 or whatever it costs to go get it, or go get an order of determining heirship so that we can properly do it and we can properly pay you and we don't have to put you in suspense or we don't have to add you to these. So does that make sense?
That was good.
Probably long-winded, sorry.
So Mitch, if I can clarify, so is XCL, I'm looking at paragraph 27 of the declaration, and it appears that XCL is trying to modify the request for pooling to exclude Petrox.
Yep.
And also the estate of Paul Soren Hansen.
That's right.
Okay.
That's right. Not uncommon for those of us who've been here. You filed a request, the division noted they got calls from individuals. I typically field 10 to 20 calls from different individuals or companies after we file these. People who've received them and either just have questions, their neighbor is on the list, all sorts of questions that we deal with. So they're usually corrections. You're right in paragraph 27 of Mr. Anson's declaration. There are 2 parties that we noted in the declarations, which were filed on September 13th. PetroX, who was only included to be pooled, they elected to participate. They signed the election, returned everything. They just didn't sign the JOA. They were included simply to oppose the same JOA on them since they've already elected to participate. As soon as they received the request, they returned a signed JOA. So they're being removed. In addition, Paul Soren Hansen, as we've talked about, his probate has now been conclusively determined by XCL, so he's being removed. In addition to those 2 parties, Monday of this week, a couple days ago, I received a letter in the mail from an attorney in Provo representing another one of the estates. And he said, oh, I just got this. I just wanted to let you know that I'm handling this. Here's the stuff. He provided essentially the information we needed. So in addition to those 2, I wanted to note on the record that we're also removing from the list of estates Keith Eldridge. So there'll be 3 parties that were initially included in this request that will not be subject to pooling in this order. And that's PetroX, Paul Soren Hansen's estate, and the estate of Keith Eldridge. And I'll make that clear in any order that comes in this.
We're going to just follow up on the Paul Soren Hansen estate. So the concern that James Hansen, it sounds like it's been taken care of, but I just want confirmation that one of his concerns was that his siblings hadn't been notified and hadn't been party. And then secondary, he had said that he did get probated, but it did sound like it was fairly recently. So I'm assuming that all kind of meshes up and the siblings and everything were taken care of and there's no concerns there.
We wouldn't have, and this is speaking out of turn, I'll let Kevin answer as well, but as a matter of practice, I wouldn't have advised the client, and the client wouldn't have agreed to remove them from the pool if we weren't confident that every owner under that was committed. It was blurry, but we take it as a thumbs up.
Yeah, you got blurred there. Good. And he also did indicate that he was getting checks on from other wells in the area. So it sounds like he's been leased in other areas. Is that accurate?
Do you know anything about his leasing, about Paul Soren Hansen's interest leasing in other units? Kevin, are you prepared to talk about that today, or?
Not really, but I mean, what I would say is it kind of goes back to what I talked about earlier, the one well, super small interest, business risk. But as I said, as we develop more in areas and, I'll take that interest times 8, 12, whatever it is per wells, the dollars start to get much higher and we start to kind of tighten up a bit on acceptance of affidavits and rely more on actual passing of title, in this case, probates and orders of determining heirships that have actually been gone through the court systems. So I don't know particularly any other wells, but that would be kind of my gut.
And it's also possible, every company has a different business risk threshold, and it's possible that Axia drilled a well earlier and thought, well, I'm confident this is an owner, we'll keep it in pay. XCL may have drilled a new well and had a different calculation. So
I would say I did tell him to get back with me if he had further concerns, and I haven't heard from him, so I'll just put that on the record. He hasn't contacted me since, so.
And he's
okay.
I spoke with him by phone about the time that you're referencing, which is why he's out. So hopefully he's going to take care of. Obviously, he's not being fooled here today. He's considered, anyone succeeding him is considered a part of this unit. So if he contacts me or XCL, obviously we'll help get him sorted out the way he needs to be in order to reflect that.
Thanks.
I have one more question. So in this request, in our exhibits, we do not have notifications from player oil and gas. And I know they were indicated as being allocatable, but they were in the other exhibit as having an address.
They have an address.
I just want to know, did we send anything out for this specific request?
We did. My understanding, and Kevin, I'm not sure if you're up to speed on the details of the mailings on this, or if that's beyond your kind of level of preparation for this hearing, because it's a pretty remote detail.
What's the question? I can try to talk to it.
Player Oil and Gas is one of those parties where we have a Canadian address for them that we believe is valid, but they don't respond. They keep getting sent back. It's on that fence between we know this is their address and we publish notice to provide them notice because we're just not sure. His question is in one of these they were, tell me if I'm wrong, one of these they were noticed by publication, one they were mailed.
Yeah, in the prior exhibit, we have that we mailed out to them, and this one we do not.
A copy of the request?
Yeah.
Yeah, I mean, they should be sent AFEs on every single, election packet. If they have an interest, Player Oil and Gas, as you guys know, is, probably seeing they're ones that we always come across, and we've done a lot of work to try to get them, more particularly try to buy the interest. But Unlocatable never get anything returned. I say Unlocatable never get anything returned from them because we do have an address. But yeah, just kind of one of the repeats, I guess.
I don't have a very good answer off the top of my head, to be honest. And I wasn't prepared, but I'm trying to pull up the certificate of service.
Yeah, sorry,
to see
this
if I
came
can.
up late.
No, it's
I
okay.
would have let you know earlier. But I just wanted to see if something had been sent to them just so we could hold on.
Let me ask you a question. Do you feel they received adequate notice, or do you feel like we should, what we've done in the past when there's questions of whether someone's received notice adequately, happens with the tribe sometimes if you don't have tribal interest and they need a certain amount of days, is prove what's there and say, that we essentially hold it, we continue it to next month's for full approval once we feel satisfied that this has been provided. So
Did this party, are they on the publication list for this matter?
I believe so.
They were on the other one.
I believe so. In the request, we'll be able to find that out pretty easily.
And then I guess that would just lead me to, kind of touched on this, but the record we have says unlocatable no known address. So what have we been sending it to? So I just so we can kind of feel a little bit better about it.
Well, the statutes are cold, right? They just are words on a page. But in reality, it's hard to know when someone's unlocatable and they just don't want to be bothered, or they think something's junk mail, or they're shut-ins or whatever. So there is an address of record for Player Oil and Gas Company, no question.
Okay.
Whether it's an effective address to locate Player Oil and Gas Company is where the question comes in. But I just confirmed they were noticed by publication on both matters. So they did receive published notice in both matters. And because we don't believe it's an effective address, I don't believe failing to mail them a copy defeats that notice in any way. But I'm happy to resend a copy and continue this to next month for full approval if that's.
In the other matter, that was returned undeliverable.
Could we just cover our bases there and send them another letter?
I'm happy to do that.
And then the divisions, their question has been answered. They were notified and probably will come back, return.
So would you like to do that then, essentially approve and continue as to Player Oil and Gas subject to next month's kind of at the December hearing of second approval, or a formal, like a player received it?
What if we continue this to the next hearing examiner proceeding? And if you could file the supplemental notice information, and then we could touch on it again at the next hearing examiner proceeding and approve it at the.
Oh, I really would like this getting taken care of this month when we read it before. So this would delay everything a month, right?
And maybe let me back up. Maybe let me suggest something. I think one of the things I try to do, and it causes problems sometimes, is make doubly sure things. But in this case, we don't really need to, right? They received lawful notice through publication. Whether it's going to reach them or not is a question of whether published notice is effective in general. but we know that the mail notice did not reach them. So if we hold this for a month to send a notice that we know won't reach them, when we already sent a notice that should reach them and did, reach a couple of people in here, I'd say it might be unnecessary. If you want to resolve today, I think we can stand on the fact that they received lawful, sufficient notice by publication.
Can we check for a second?
Yeah.
Sorry, this just came up with the last second.
No, don't worry about it. This So you're saying
They're just not in the exhibit.
To the notice.
We should probably go back.
I think I can mail it.
Discussion.
Okay.
Hey, were you, what do I get seeing here?
I don't know. I'm
Are
so
we back
missing.
on the record?
What?
Are we back on the record?
Oh, this was just informal, yeah. Okay, let's go back on record.
Oh, it does. It shows on there. On the second page, it says they were. Oh, they did receive mail notice.
That's what it says.
Okay.
Exhibit A of it.
There just wasn't a return of service filed. Is that what you're saying,
That's
Andrew?
what it says.
There was no proof of mailing.
Yeah, the green slip hadn't come back yet.
Who is this we're talking about?
We're still talking about player.
Claire?
Yeah.
I think you're just saying you don't see the green card or return receipt.
Well, and their address isn't listed, but in the other one, it sounds like their address may have been listed. Is that?
So, in the prior matter, exhibit I has player oil and gas, and we have their proof of mailing. In this one, the proof of mailings they're exhibit G, and they aren't in there. And so I just wanted to
You're
confirm
talking-
that they got sent.
You're talking proof of mailing of the election letters.
Yes.
Oh, okay. Okay. Yes. Kevin, I think we've clarified what we're actually, the question that I answered was wrong. What he's wondering is, do you have proof that Player Oil and Gas received the election letters for the two Murph wells in the 2560?
Or the
Sorry, I was on the phone with Des trying to look up the information. What was the question again?
Yeah, we're back on the record now. Essentially, we clarified the question was not relating to notice of the request for agency action so much, but the proof that we mailed the election letters to them. It sounds like the exhibit accidentally omitted possibly proof of mailing for Player Oil and Gas on the 2 Murph wells in the 2560. I guess in lieu of a document that you can produce immediately, do you know if Player Oil and Gas was notified of the wells? I mean,
That's what I was trying to pull up, and I'd called Des, who's our land tech, who sends out all of our election letters. So I was going through trying to find that record. It will just take me a few minutes to try to track it down.
are we waiting on me to witness?
Well, if he can find that, that would.
Yeah, sorry, Des is out of the office. So I'm trying to decode her filing and sense. So I mean, I know we've been trying to track Player down forever. I can tell you that, and I know we send them well proposals. It's one of the repeats, but I can keep looking.
Yeah,
I found it for the other 5. So I'm just trying to find it on the section line wells, but I have proof that we sent it on the the non-section line wells. But I'm trying to track it down on the others. So.
Five-minute break, let him do it without everyone watching him, and maybe we'll come to that. We'll get some more time.
Yeah,
We'll go off the record for now.
Kevin? Yeah, nice.
What's that? I'm gonna try to call Daz. Let me see if I can't get hold of Daz.
Okay, we're on break.
hey, Mitch, and we can come back on the record. I know people walked out, but I can just tell you what I got. And I found it online. So
Hold on, Kevin.
yes.
Just hold on one minute until the hearing examiner is back in the room.
Okay, no problem.
Mr. Anderson's got an update, and I think I've kind of come up with what I think is an update / explanation as well. So, Kevin, do you want to go first?
Yep, I got it. Okay. So Des, so we sent the packets to Player Oil and Gas on the 1280s, which was the, 23S, 23G, 23B, 23O, 23Y, those wells.
For the record, as well as an issue in the 136.
Yeah, in the first one. Yeah. And then those were, that packet was returned to XCL. We then sent it back again because we got it back. So we sent it back again. After we sent it back a second time for the same set of wells, we received a phone call from the folks who were in that particular suite, and we have the voicemail recorded. She said that she's been in that office for 15 plus years, and Player Oil and Gas is no longer there. And so she said, she was going to send it back. So she sent it back to us. So then when it came to sending the two packets for the 2560s, we did not send it because we knew we did not have the proper address, or that was the last address of record. So like we've done, Des went and looked to try to find another address of record, and she could not find any other addresses. So instead of bugging the lady and sending it to her again, she did not send it to that address. And I have the email here, or excuse me, the voicemail here for evidence, and I'm more than happy to play it. I don't know if you guys would be able to hear it, but her name was Geraldine Keene from the IBI group.
Yeah, it looks like people here are interested. So if you can play it.
Of course. Here we go.
They're not interested.
Oh, it's a minute 31 seconds. Are you sure you'll never get that minute 31 back? So.
Well, while I'm looking and while we were on break, we kind of had a discussion and guessed that was what had happened. And just to bolster what Mr. Anderson said, in looking back during the break, in cause 13222 in Mr. Anderson's declaration in page 18, the election letters mailed to the parties in that cause were mailed in July 2022. In Mr. Anderson's declaration in this cause, 13223, again on paragraph 18, it says they were mailed in September of 2022. So that matches up with what we're hearing. In the first matter, there was a valid agency record, or at least believed to be, returned price as undeliverable when they mailed out notices the second time around as a courtesy to the person who had called and said, please don't send us anymore. They didn't send it to that address. So they are truly unlocatable in both, but identified as such explicitly in the second.
Okay. Well, that helps. I will go ahead and declare them unlocatable in the second matter. And we'll go ahead and, unless the division has any more recourse.
No, the division is satisfied with that.
We do two things just before we finish up. I don't believe they were sworn in this matter. So if they could just confirm that they were still testifying under oath in this matter, as in the last matter, that it continued on.
Do we need to re-swear them in? Are these, I mean, this is one proceeding. If it was just called up in a board hearing and they were called back up, would we swear them in again?
I don't think so.
I think we typically say you're still under oath.
I think we do for each proceeding. So
Let's do it.
I'll just confirm that it was under oath and it was true and correct.
Did you guys hear that discussion? Mr. Anderson, Mr. Gravy, will you raise your right hands and I'll have her administer the oath for you.
You solemnly swear that the testimony you shall give is the truth, and the whole truth, and nothing but the truth, so help you God.
I do.
And both of you, I'll start with Kevin. Mr. Anderson, can you confirm that the declaration on file and the testimony you just gave are your true and accurate and full testimony here?
Yes, I do.
And Mr. Gravy, same thing, the declaration on file and the testimony and discussion today, are those your full accurate testimony from the hearing?
Yes, it is.
Thank you.
Okay, thank you.
Division, do you have any? I wouldn't think so in the last 20 minutes, hasn't changed.
No, based on what we've heard here and reviewing of the affidavits, satisfied with the test.
Okay, we'll accept them as expertise in their areas of study. Okay, just for my review, the 300% rule penalty seems appropriate in this case. The average weighted land royalty 14.636705. Reviewed that. That seems appropriate from my analysis. And there is 97.552370% leased in this matter. So at this point, I would recommend that we take exhibits at this time. And if we do better than we did last time.
No, we're not going to do better. We're going to do worse. So I think I've identified what happened in the earlier mistake. They weren't mislabeled. They're supplemental exhibits, but I think they were just labeled as the next letter because we have A through J, A through K in the prior one, and it was supplemental exhibit L, but it should have been supplemental exhibit K. In this one, we've got exhibits A through J, and what was submitted was supplemental exhibit K. So it was just given the next number designation, but they are meant to be supplements of the proofs of service. And in this one, it's I, not J. I'll clarify the exhibits. For the purposes of this moment, I'd like to move for or request admission of exhibits A through J and soon to be corrected supplemental exhibit I.
Okay, so accepted. Do we have to accept the affidavits or is that taken care of when they were sworn in?
Let's put them in.
Yeah,
Yeah, they're already part of the record, but it seems like we typically like to admit everything through that.
okay, let's do that. So add their affidavits. So this time I recommend that the request for agency action as stated be accepted for the board review. And at this time, Mr. Mayo, would you prepare that order?
I would. I'm happy to. Thank you. Same caveat. I'll try and get it by the end of the week.
Okay, and that's with the 3 parties that were identified in this proceeding that will not be compulsory ruled.
That is correct.
Any more matters from the division?
Nope.
Okay, this time we'll conclude this hearing and appreciate everyone's participation and your witnesses participating online. Mitch, thank you.
Well, thank you.
Thank you.